permission to appeal in the matter of AstraZeneca and Glenmark.
Yes, Mr. Pritchard. So, can I remind everybody, this is an application for permission to appeal only at this stage, and that is something that would normally be dealt with entirely on paper. So can I begin by seeing if I've read what I need to have read? I've read the judge's judgment, I've read your grounds of appeal, and I've read your skeleton argument. I've also seen a letter from St Mason's on behalf of Teva. Is there any other document that I need to have read at this stage?
I don't think you do, my lord. I'm very grateful for that indication. Also grateful my lord has found the time to write it and read it, given it's 10:30 on Monday morning.
Right, so I will give you and Mr. Abrahams 20 minutes each.
My lord, I'm grateful. In that case, I'll cut straight to effect with the first point. We do say, and my lord has seen, there are 3 grounds of appeal, which I'm going to urge my lord have a reasonable prospect of success. But I do also submit that there is a significant importance to this appeal in relation to PI injunctions in pharmaceuticals. My lord will have seen from the learned judge's judgment, this is a case where he has found that multiple generics will enter the market, where he has found that prices will go down between now and the form of order hearing. And in those circumstances, we say the orthodoxy would be that there would be likely to be an interim injunction. We've set it out in our skeleton, para 13, the well-known section from Terrell. Our skeleton is at tab 4 and tab 13. I don't think I need to go to Terrell, but paragraph 13, one sees the general principle. And the point I want to quickly, I mean, my lord will be very well aware of the cases, but in Urim, in Cephalon, in Actavis, these were cases where there wasn't multiple entry and a spiral. So they are all examples of a different sort of case. Now, we're obviously guided with one piece. It is an important, the letter that has come in is obviously important, my lord, because it shines a light on what we submitted to the learned judge, that there is likely to be a rapid generic entry and a rapid, therefore, reduction in price for the generics. That is reinforced. But we do submit that all one can really know at this stage is that there is going to be generic entry and there is going to be price depression. As the judge found, it is almost impossible to predict what's going to happen between now and the form of order hearing. Now, the judge rightly said in our submission that he has to look at 2 things. He has to look at the acts between now and the form of order hearing, but he has to look at damage that is going to take place either between now and the form of order hearing, or damage which is going to take place, manifest itself afterwards. And if I can just pause there, my lord, where we have reached in my submission as of today is somewhere that is very uncertain in relation to what the state of affairs will be at the form of order hearing. We've set out the points in paragraph 16 of our skeleton, but the things that one cannot know is whether the market has become fully or partially generic, whether the patent has been found to be valid or invalid, on what basis. One can't know at this stage whether permission to appeal is going to be granted or not, and if so, on what basis. One can't know whether there's going to be an operative injunction pending the appeal, and one can't know what the position of the other generic parties is likely to be. So that, in those circumstances, we say this is a change of approach by the learned judge. It's certainly a different approach, an approach that wasn't considered by the Court of Appeal in Urim, Actavis or Cephalon. The facts are different because of the multiple entry. And that, we say, is one reason why this is appropriate for consideration by the Court of Appeal. The second...
Now, on that point, I have a question, which I don't know if anybody in court can answer. It's dangerous to rely upon memory because memory is fallible. But my memory is that after Urim 1, there was an application to the Supreme Court for permission to appeal.
There was, my lord.
Which was refused. But my recollection is that in refusing permission to appeal, the Supreme Court accepted that there was room for argument about the test that was applicable in such cases.
That is precisely right. My learned friend Mr. Lunt will get it out of Terrell, but it's recorded in Terrell. What happened was Mr. Waugh and Miss Moggridge argued really along the lines that were argued in the Clonmel case in Ireland, that one shouldn't rigidly apply the stages in American cyanamide. One has to take a rather more holistic view. And my lord will have seen, I think, from looking at our ground one, that underpins our argument in ground one, together with the fact that one has to take into account uncertainty at this stage. So we're two-pronged. We partly rely on that, and we partly rely on the position that was the case in Nurem 2, but my lord is entirely correct. My understanding was Nurem 2, it never got to the Supreme Court because things were moving too fast, effectively.
Oh, it was Nurem 2, not Nurem 1.
Um,
I mean, I did search the Supreme Court website this morning, but I got a nil return.
yes. So it is, my lord, I believe, I don't know if my lord has a copy of Terrell.
Not with me.
But my lord is correct. I can pass this up if it's of assistance.
Yes, thank you.
It's 228 at the top of the page, my lord. My lord, my understanding is the same as my lord's recollection.
Yeah. All right. Well, in the meantime, while it's coming up, go on.
My lord, the second point, which is important, is that if this is right, we've got a situation where a party has launched very close to judgment, which is likely to cause a pile-on, a generic pile-on, and that, as a matter of policy, creates a situation where there's going to be a temptation in the future for generics not to wait for judgments of this court, but to come on a disorderly fashion before judgment. And again, we say that's a matter that ought to be looked at by the Court of Appeal. And related to that, a clearing the way point, and my lord is of course familiar with Apotex in 2003, there is an argument here about whether Glenmark properly cleared the way or not, and I'll come on to it later, but in short form, we submit they didn't do enough. It wasn't enough back in 2004 to seek a trial in 2005, and then say, well, as we didn't get a trial in January 2005, sorry, my lord, from the court, we've got a free pass. We've asked for one, but we've got a free pass without doing anything more to launch at any time thereafter, which is effectively what they are saying. And that comes very close to the second argument of, should there be an orderly procession to judgment, or should instead there be basically a free-for-all? Now, I'm going to come on to ground one. Before I do, but I'm very conscious of the time, my lord will have seen that on the facts, and I understand that these were accepted by the learned judge, the market for this particular drug, dapagliflozin, is very large, it is growing, its share varies in comparison with other glyphosines, and it is being promoted to potentially up to another 3.7 million people. It's potentially those are there. And the reason for saying that is this is not a stable market case in my submission, and I submit the judge didn't find it was a stable market case either. And that is obviously, in my submission, a very important factor when looking at the merits of an interim injunction such as this, if one's going to use the crystal ball. Ground one, my lord, has already effectively alighted on from the Nurem side, which is precisely how should one look at American cyanamide. We submit, and this is what Lord Gough said in Factortame, the steps are a guideline, they're not a straitjacket. And the danger, and we say this very respectfully, the learned judge below, is that if one is too blinkered, one tries to come to a very deterministic decision on adequacy of damage. One is in a position of having rather inadequate facts. And that leads to, in my submission, a great deal of uncertainty. It's the sort of uncertainty that my lord, and also my lords, Lord Justice Burse and Lord Justice Newey, have referred to in Nurem, which we put the quotes in the skeleton. But one can see here that one doesn't have to be far wrong to get into very difficult territory. And I would pray in aid, respectfully, that the letter over the weekend shows that. The learned judge came to a perfectly sensible decision, one might say, on the facts of what he thought the generics were going to do, per contra my client's submission. But we now see, exactly as we said, it's very uncertain. And one sees that. So that, very conscious of the time, we say that first point is an important point of principle. If the court is going to look again, we submit it should, for the reasons I've said, whether an interim injunction should be granted in these circumstances when generic pile-on is likely to occur, then it needs to consider that uncertainty point, and in my submission, give clear guidance. Because the position from the part of the industry is, well, what else can they do? They can say they're launching, they can do as they did here, which is to write letters and ask the generics what they're likely to do. But ultimately, they cannot know which generics are going to launch. They cannot know, in this case, we do not know how much of the market Glenmark is intending to supply because they haven't told us, and we certainly don't know what anybody else is going to do. So with that information, it's extremely difficult to predict what's going to happen. And my lord will have seen that the learned judge criticised AstraZeneca's evidence on the basis that he said, well, I think they weren't highly unlikely to lower their prices. Now, in my submission, that's an unfair criticism because what the witness, Dr. McGill, actually said was, this sort of scenario puts AstraZeneca in an extraordinarily difficult position. It either lowers its prices, cutting its profits, or it keeps its prices up and it loses market share. Now, the reason that evidence in my submission is written that way, why it's not deterministic, is because AstraZeneca are simply not in a position to know what they're going to do until they react to the market. That's an example, if I put it that way, of the uncertainty. So I do say that in itself is a point that ought to be considered, that there is guidance is required. One can see, and we have this in the skeleton, my lord, one sees what His Honour Judge Hakon did in Rivaroxaban, which is much more in my submission based on that uncertainty approach than a deterministic yes or no to an adequacy of damages based on the limited evidence. So that's my first ground, my lord. I'm getting second ground, my lord. There is a problem in my submission with the way the learned judge approached the facts. I've already said the learned judge correctly said that he had to look what happened between now and the formal order hearing, absolutely rightly so. He also correctly said he needs to look at the damage that manifested itself after the form of order hearing. Again, rightly so. But what he's failed to do, if my lord will have noticed from the judgment, there is the pecuniary loss point, which judge addresses. There's also the point about the growing market, NHS reclassification, and matters such as the joint workings promoting the growth of the market. Now, the judge finds they are unlikely to change before the form of order hearing. And I'm not seeking to go behind that, but what I am seeking to say is the learned judge's reasoning fails to take into account what happens if the market has in fact become fully genericized at the point at which the form of order hearing happens. First of all, my client is in a very different position if the market is fully or partly genericized, coming on and saying to the court or the Court of Appeal, we would like an interim injunction pending the outcome of an appeal. Of course, we don't know whether that would happen or not. We don't know whether there would be an appeal or not. But if it did come along and ask for an injunction, it's in a very different position because it's no longer a pristine market. If it doesn't get the injunction or doesn't ask for the injunction for whatever reason, then those effects to reclassification by the NHS or joint workings will, in my submission, kick in eventually. And they will kick in because two things have happened. First is the ability to get the injunction has been deeply reduced, it's unquantifiable. And because of that, looking forward, these effects will, if they don't come in the next 3 months, will inevitably come in my submission later on. And the judge didn't reject the idea that there wouldn't have to be a reclassification if the market becomes genericized. I mean, it's probably common ground, it will do eventually. So that again, my lord, conscious of the time, is the basis of the second point. There is a failure in the judge to properly appreciate his own direction as to the manifestation of damage after the event. Now, my lord, that takes me swiftly to the third point. And this is now looking at damages on the cross-undertaking for Glenmark. My lord will have seen the learned judge found that in his view, in his judgment, the calculation was considerably more difficult for Glenmark than it was in relation to AstraZeneca. And in my submission, that doesn't properly stand up to analysis. And we say at most he should have found, in the worst case scenario, that they were of a similar scale of difficulty. And where he's fallen into error in my submission really in two ways. First is he considers one of the two counterfactuals, the single entry counterfactual, and he finds that even though we know, or he's made a finding rather, as to the reduction in price by Glenmark, it would nonetheless be difficult if they were the only generic in the market to calculate their loss. So I say that is obviously an overstatement. The possibilities for debate on that go to volume. In relation to volume, one is effectively dealing with, and I think that the evidence this was effectively uncontroverted, with something that is close to a commodity. This is not a biologic. So Glenmark would come in at 10 to 20%, and they would argue that they would presumably shift as much of their stock as possible. There might be a little bit of argument around the edges, but it's nothing very difficult. If there are multiple generics entering the market, then in a short point, we say the calculation, whether it's the calculation of damage or the calculation of the uncertainties, it becomes source for the goose and source for the gander. Certainly when the market has become saturated and fully genericized. The other point is that the learned judge failed to take into account Glenmark's own evidence, which was that generics would tend not to drive down their prices and that each generic would get a slice of the pie until the market became saturated. Now, if that is the case, or at least until saturation occurs, that is something that is much easier to quantify. So I say that's the third ground. I say that's also the question of, sorry, I was passed a note, I need to deal with it. There's one other point on the third ground, which I think is strongly affected by the letter my lord has seen that came in over the weekend. My lord will have seen, if my lord turns to the second page of that letter, the penultimate paragraph.
Where do I find that?
There's the letter my lord we handed up to my lord. Oh, well, sorry.
I received it electronically and I've read it electronically. I don't know how I've got it.
And we didn't hand it up to you, we handed something else up to you. So if my lord were to turn on to the second page and the penultimate paragraph, my lord will have seen what is being said here, which in our submission is entirely unsurprising, given who it's written on behalf of. But the point I would draw my lord's attention to is the last line of that penultimate paragraph in relation to first mover advantage. Now, what this demonstrates, my lord will have seen that the learned judge below put a great deal of weight on Glenmark's first mover advantage, which is really, in my submission, a first mover advantage that only exists if Glenmark are the only generic on the market. The moment that other players, such as the player who, on behalf of this letter is written, come on the market, they all come on very quickly. And the idea of a first mover advantage in my submission becomes effectively illusory, or certainly not nearly as great as the learned judge found. My lord, I think I have had my 20 minutes. It's a question of whether I can assist my lord on any other points.
No, thank you very much.
Turn my back and check I haven't missed anything.
Yes, sir.
I'm grateful, my lord.
Mr. Ellis.
My lord, obviously, my overall submission is that this is that the judge evaluated the evidence and applied the established approach laid down by the House of Lords and by this court, and so for that reason there's no prospect of the court interfering with the judge's decision. And your lordship will have seen from the judgment that the judge is very focused on analysing the evidence in great detail, and there's no suggestion by AstraZeneca that he overlooked or ignored any of the evidence. The complaint is only about the judge's evaluation of the evidence, but there's no arguable point in that. Now, dealing with my learned friend's three grounds. Ground one is what I understand to be a holistic approach, which is basically skip American cyanamide stages 2 and 3 and go straight to cyanamide American Sign in stage 4, the balance of convenience, which is effectively what they do in Ireland, as the quotation that my learned friend showed you. Quite apart from that being contrary to the House of Lords authority, there's no possibility of an appeal succeeding on that basis, because the judge went on in great detail to consider the balance of convenience. He considered the harm to AZ if an injunction was not granted as part of it under the heading of stage 2. He considered the harm to Glenmark if an injunction was granted under the heading of stage 3, and he concluded at paragraph 101 that the balance of convenience was very strongly in favour of withholding an injunction for the reason he gave in really great detail on the basis of a focused analysis of the evidence. So that point, even if it were open to this court to depart from the House of Lords, just wouldn't be a ground of appeal. My learned friend quoted Terrell, and what's striking about the quotation from Terrell is that Terrell is directed expressly to a case where I don't want to misquote it, so it's in my learned friend's skeleton argument. Paragraph page 26 of the bundle.
Yeah.
And 2, 4, 6 lines down, it refers to the fact that the patentee, it will permanently depress the patentee's price, and then a few more lines down, they will not be able to put the price back to previous levels. In this case, of course, the judge had evidence from both sides about what was going to happen to the patentee's price, and he said himself in the judgment that this was a particularly important point, more important than other generic entry. And he said that on the evidence, the patentee would not lower its price. There were very good reasons why it wouldn't lower its price. And even if it did, it would be able to put its price back up on the evidence. So the judge accepted a real risk of other generics entering. He made that absolutely clear. He was proceeding on that basis. And therefore, Teva's letter changes nothing. That just shows that the judge was right to proceed on that basis. He accepted that there would be generic price depression, i.e. the generics would compete at if there were multiple ones, would compete at a price but lower than the patentee's price. But he considered with great care the evidence about what the patentee would do and concluded the patentee would not lower its price. And that's why this wasn't one of the cases that's discussed in Terrell. In relation to ground 2, the essence of ground 2 is that granting an injunction would make it more difficult for AZ to get an injunction pending appeal if it lost the validity trial. Now, AZ did not run this argument below. Indeed, it ran the opposite argument. I argued that the judge ought to consider what would be likely to happen at the form of order hearing if he granted or withheld an injunction, as the case may be. AZ argued that the judge should simply consider the period between now and the form of order hearing and should not consider any applications that would be made at the form of order hearing. So in terms of evidence, that was Mr. Stothers 1. It's in the supplemental bundle at page 13, paragraph 43. He said, we're only considering that period, don't consider it. And at the hearing orally,
Well, I don't quite understand that. I mean, maybe you're obviously more familiar with this, having had the benefit of arguing it last week, and I'm only come onto this case this morning. But as I read the judgment, the judge accepted that he was only concerned with the period between now and the form of order hearing, but he also accepted that he had to consider damage potentially suffered by either party after the form of order. He absolutely
did that. He absolutely considered that, and you see that from the judgment. But what my learned friend is saying now, as I understand it, is he should have considered, well, what will happen at the form of order hearing? If ground 2 is saying, what will he consider at the form of order hearing, and will there be an injunction pending appeal? Because my learned friend said he's not seeking to go behind the judge's finding that these damages that he refers to, such as joint workings, would not be affected between now and the form of order hearing. He's saying they'd be affected after the form of order hearing, but that depends on whether or not there's an injunction.
Well, the starting point for the argument, as I understand it, is that there's considerable uncertainty as to what the court will do at the form of order hearing.
Absolutely, but he was not. He was urged by AZ and accepted the urging not to try and work out what would happen at the form of order hearing, because that was a matter for the form of order hearing. That's recorded in the judgment at paragraphs 27 to 33. And as I say, he's there rejecting my argument, because I had arguments based on what would happen at the form of order hearing, depending on whether he got what he did on Friday. And my learned friend successfully argued against that. And you see that at 33, he records that.
My lord, one has to read 32 immediately before, in my respectful submission.
Indeed, absolutely. So he's considering the damage caused between now and the form of order hearing, and the damage that manifests itself later as a result of activities between now and the form of order hearing. But he's rejecting the argument recorded in 29, well, 28 and 29. You just can't say what's going to happen.
Well, sorry, maybe I'm struggling to understand your point, but look at what he says in the last paragraph of 29, last sentence of paragraph 29. He says, I believe it would be wrong for me to prejudge what might happen at the form of order hearing.
Absolutely.
And that's, as I understand it, the point that Mr. Pritchard is relying on. He's not trying to argue that there should be some form of view taken as to what's going to happen at that stage. He positively relies upon that and says that's absolutely right. Don't prejudge what happens at the form of order hearing, but what that tells you is there's considerable uncertainty.
Indeed. If this may simply be because I've misunderstood my learned friend's point under ground 2. I thought that he was saying that the judge should have taken into account the effect of his decision on the form of order hearing, which is, as I say, certainly whatever ground 2 is saying, there is no sign of any argument of that sort before the judge, and we do submit that it's not open to AZ to challenge an evaluative discretionary decision on appeal by raising a new point which is not argued before the judge. Now, if I've misunderstood Mr. Pritchard's point, then I've misunderstood it. But what I can submit with confidence is that whatever ground 2 is, it's a new point that was not argued before the judge. In any event, what my learned friend then says is, well, then after the form of order hearing, the injunction, if there's no injunction, then these things will happen, and they're set out in his appeal skeleton at paragraph 50. But the position is absolutely the same. The judge considered those matters. He considered whether or not those would be likely to occur, and held on the evidence not. And there's just simply no basis for saying that the things which my learned friend complains about in his paragraph 50 are likely. Excuse me. There's no basis for my learned friend to say that this court should interfere with the judge's decision based on the evidence as to whether or not those things are likely to happen. Then in relation to ground 3, the key point here, as I've understood it, is that the judge's approach to the damage suffered by AZ and Glenmark was inconsistent. And there's absolutely no inconsistency. It is, as the judge pointed out, the reason for the answer to the 2 questions being different is because the difficulty in constructing the counterfactual is different. If an injunction is not granted, then the court has to construct the counterfactual if an injunction had been granted. In that case, it's easy. The counterfactual is that AZ would be supplying 100% of the market at its current price, at its current profit levels, which it knows. So that's easy counterfactual to construct. And then if an injunction is granted, it would not be so easy to construct the counterfactual. And the judge gave reasons in great detail, again, with a focus on analysing the evidence at paragraphs 87 to 100. And obviously I can't go through those one by one, but he's looking in a lot of detail at at all of those uncertainties in constructing the counterfactual in that world. And it concludes a range of evidence and reasons, all of which are open to him, and many of which AZ has nothing to say about on the appeal. Remember, the judge accepted their submission that there's a good chance that there would be other generics entering the market and that there would be generic price competition. And therefore, if he grants an injunction, trying to reconstruct that world and what would have happened is extremely difficult. And he had lots of evidence and detail on that point. So there's absolutely no inconsistency in his answer to those two questions. They're just complaining he came to a different answer. And in their skeleton argument, they say the judge erred by failing to adequately consider the comparative scale of the irreparable harm to AZ as opposed to Glenmark. And that's just simply untrue. You've seen the section where he goes through in great detail referring to the evidence, the irreparable harm to AZ, then the irreparable harm to Glenmark, again with an impressive focus on detailed evidence, and then he compares them at 101. And they just don't like the outcome, but in a sense the outcome's inevitable because that was the evidence. My Lord, finally I should mention what my learned friend said about clearing the way. Now what you'd have seen is that the judge accepted that Glenmark notified AZ and gave them just shy of 4 weeks' notice of an intended launch. And they notified as soon as they were ready to notify, in a position to do so. And then Glenmark acted sensibly and gave further undertaking. So in fact, the hearing was much further away. It was well over 5 weeks away, and Glenmark gave...
Yes, but the criticism, as I understand it, is that while your clients behaved entirely properly during that period, what they failed to do was to put people in an adequate position to form a view as to what the appropriate course was at an earlier stage.
Indeed. And our answer to, and there is no arguable point in that for two reasons. First of all, while of course there is authority that the points you've just put to me may be relevant to the balance of convenience, the judge found that damages would be an adequate remedy for AZ. So the first point is that the balance of convenience doesn't come into it. The second point is that even if one adopts the Irish approach of jumping straight to the balance of convenience, the weight to be given to this factor is a matter A, for evidence, and B, for the judge to evaluate. And here, the judge considered the detailed facts and made an evaluation that was open to him. So he considers the evidence at paragraphs 14 to 16, and he doesn't recite it in detail because a lot of it was confidential. But you see him saying he's considered that evidence carefully. And then at paragraph 103, so it's 14 to 16 is where he's considering the argument and the evidence that goes to that argument. And then it's paragraph 103 where he does his evaluation, and that's a classic example of a judge taking into account the evidence and saying, in the circumstances of this case, bearing in mind everything else in this case, this is the weight that I'm going to give to this point. And again, there's no basis for this court to interfere with the judge's evaluation as to how much weight this point should be given on the basis of the facts, which he's evaluated carefully. So in a sense, this is a paradigm case of a point that AZ complained about, but whereas the reality is that the judge had detailed evidence before him. It wasn't just simply assertions. He considered that evidence with real care and in a measured way, and then he made an evaluation of the weight to be given to that particular point. And at no point in that process is there any arguable error of principle. We obviously say that he made absolutely the correct decision and that any judge would have made the correct decision. But in terms of the test which your lordship is applying, there's just simply no basis for saying that he didn't, that this court is in a position to interfere. So those are our answers to the three grounds of appeal and our answer to the appeal generally.
Very good. Thank you very much. Well, the only question I have to decide at this stage is whether or not this application for permission to appeal meets the well-established test, which is that of a real as opposed to a fanciful prospect of success in my judgment, the grounds of appeal are sufficiently arguable to meet that test, and I will accordingly grant permission to appeal. Now, I assume in those circumstances, both sides would be wanting expedition of the substantive appeal.
I necessarily do have to ask for that,
Yes.
my lord, and a holdover injunction.
Well, that's the next question, but let's deal with expedition first.
Yes, of course.
I assume you would support expedition, Mr. Abrams?
Absolutely, we can be ready absolutely as soon as two judges can be got together, my lord.
All right, well, I think what I will do is, in order to ensure that the appeal can be properly prepared in good order, is to say that there shall be an expedited hearing of the substantive appeal, not before Monday, I think it's the 14th, no, that's not right, the 7th, sorry, not before Monday the 7th of April, and not later than Wednesday the 16th of April. So it will be in that window shortly before the Easter vacation.
So my lord, if the other side have prepared their skeleton argument, and so there's nothing more for them to do. We can prepare our skeleton order in much shorter order than that. So certainly we could be ready for a hearing much sooner than that. I mean, we could be ready tomorrow. Your lordship was able.
Yes, but I have to bear in mind assembling a constitution to hear this case, and I think that it will be difficult to assemble a constitution with the requisite balance of experience in that timescale. So no, I'm not going to go back on what I've said. But I take your point that your clients want it as soon as possible.
My lord, I'm grateful for that. That does take me, and it's in the back of our skeleton, to the application for the holdover injunction. We say...
Well, let's find out from Mr. Abrams if that's resisted.
Oh, yes.
Are you willing to give an undertaking until determination of the appeal?
So I don't have instructions. I'm not able to offer an undertaking now on my feet to the sort of time that your lordship's talking about. Just I'm not in that position.
Are you able to get instructions?
I mean, I can ask. I'd probably require you to rise for a few moments.
Certainly, I'll do that.
He said from the...
No, you didn't.
So we just have to be best able to do justice.
And you can rely on the letter as well here.
Sorry.
Debit's letter. I think because you have a price collapse, so it doesn't give it because we pay debts. So you also need to get because this is
Sure. Just keep
sorry.
that word out.
Sorry, yeah.
You're supposed to be on the brief. You'll be on to there.
Yeah, don't let me forget that.
Just give me 30 seconds and I'll ready to go.
All right.
So, Mr. Abrams, you've been able to get instructions.
Yes, my lord, I have. And I should tell you that my learned friend is hearing this at the same time as your lordship is hearing this. I've got instructions to give a qualified undertaking. The undertaking would be on the same terms as the undertaking given, well, the various undertakings given to date to maintain the position, including up to this hearing, and is subject to the same cross undertaking that AZ have given in relation to those undertakings, with an additional qualification, and it's this. Currently there are 175,000 packs of product of Glenmark product in lorries ready to go to wholesalers. That's in the context of a market where the size of the market is 1 million plus packs per month. So 175,000 packs is not very much at all, and allowing my clients to put those into the wholesalers will not change the status quo, will not cause AZ any harm at all. But on the other hand, it will enable my clients to preserve their position as the first generic on the market and substantially ameliorate the damage caused to my clients by being injuncted stroke giving the undertaking until then. So in my submission, the right thing to do is for your lordship is to accept that qualified undertaking on the basis that the qualification causes negligible harm to AZ and can easily be quantified in damages. I mean, it's just 175,000 times their known profit margin.
Well,
Whereas-
to be clear, there's no damage suffered if the product goes no further than the wholesaler.
No, it would be going to the, sorry, I apologise if I was unclear. It was going to the wholesalers for release by the wholesalers.
What's the point of that?
Well, as I say, the point of that from my client's perspective is that it enables my clients to be the first mover and maintain their position as it ought to have been, that they're the first mover, at the cost of no damage to AZ that isn't readily calculable. Now, my lord, in the alternative, we would certainly ask that they can go to wholesalers, but not to be released for sale. And that is certainly that is essentially my fallback position. You've identified that, so they would go into be provided to wholesalers on the basis that they couldn't be sold by the wholesalers, pending a further order of the court. But in my submission, when one's talking about maintaining the position between now and the hearing next week, and not rendering, having the Court of Appeal being in the position to do the best justice, if on the one hand the Court of Appeal decided that they should grant an injunction, then having allowed those 175,000 packs to release to market would in no way undermine that injunction. Whereas if the Court of Appeal decides not to grant an injunction, then my clients may well be prejudiced by the fact that they couldn't be the first people to supply product, not least because, as we know, Teva are raring to go and are not under an injunction. So particularly bearing in mind the position of Teva, who are not injuncted, and I'm not aware of an application to injunct them, then it would certainly be fair and the right way of maintaining the balance to allow my clients to put 175,000 packs into the market so that they can maintain their position as first mover, and that's the correct balance in my submission.
My lord, can I start backwards in relation to the company referred to in the letter? My lord, has been referred to several times now. They have asked, as you've seen, Vincent Mason's asked whether we were going to seek an interim injunction. My instructions are, given my lord's decision this morning, we inevitably will be going back to them on that basis, because we have to hold the ring, and that doubtless will be true of every other generic who tries to launch between now and the time that the Court of Appeal is able to constitute to hear this appeal. And there is it is a short period before the appeal. It is, one has to bear in mind, this is I think will be the fourth, it may be the third, if it's not the third, it's the fourth undertaking that would have been given since the 17th of March. The original launch date was 17th of March. It has already been pushed back a number of times. Pushing it back a little bit further won't, in my submission, make a substantial difference, not least because the learned judge below regrettably was interrupted in his preparations, so doubtless the form of order hearing will have to go back as well, because we had to go and see him. And then, my lord, one does have to ask why it is they say there can be no damage, because if it matters to the market for them to put 175,000 packs on, then it matters in my submission to the market. They are jumping the gun, they are altering the market, it is no longer pristine, the situation is not the same as it was otherwise. It may be less damage than it would be if it was 1 million packs or 500,000 packs, but it is a substantial number, and it's a substantial number that my learned friend thinks makes a material difference to the way the market views this product as well as his client. So in my submission, the short time between now and the constitution of the Court of Appeal to hear this appeal, all points in the direction, as one gets from the scatter, or I can't pronounce scat probably, my lord, sorry, in solo capital case. How's the best way to preserve the position of the Court of Appeal to do justice, keep the market pristine in my submission until effectively the very short period until the appeal.
What about the fallback of the current product in the lorries going to the wholesalers on the basis that they're not then released for further sale?
The only difficulty with that is a matter, I've taken instructions behind, I suppose is a matter of policing. They then presumably will be said to have left Glenmark's control.
Well, it will have to be on the basis that they put in place contractual arrangements to ensure that they don't cease to be under their control.
Can I take instructions on that very specific point? My lord, if the undertakings were given to the court, that they wouldn't be released from their control. In other words, if they were released from their control, it would be Glenmark's problem and not the wholesaler's problem, then that, I think, would cover the points. Those are my submissions from behind.
All right. Mr. Adams?
Well, my lord, it's important to bear in mind just how small an amount this is, 175,000 out of the context of 1 million packs per month. And this really is a balance of convenience point. It causes them no inconvenience to have them released to sale to pharmacies, but it causes my client real inconvenience if the result of the giving the undertaking all the way until next week is that it doesn't become the first mover advantage. And it is a matter of concern that your lordship should bear in mind that my learned friend is...
But how does it help you if we assume, I mean, obviously I'm not prejudging the matter, but if hypothetically the appeal is loud and an injunction is granted, let's say next week, how does it help you?
Oh no, in that situation it doesn't. The reason for doing it is so that the court can be in the best position to do justice if it decides not to allow the appeal. In that case, my client, having given an undertaking to the appeal, will have potentially prejudiced it irredeemably, because by that stage other generics will be on the market, and my client, by giving undertakings until that hearing, will be prejudiced irredeemably, and the court won't be in a position, the Court of Appeal won't be in a position to do justice by allowing my clients onto the market in the way that they should have. And it's in that context that it's very concerning that Mr. Pritchard was relying on the fact that we've given undertakings to date to maintain the position. Obviously, that's something that benefits the court by meaning that it can deal with things in an orderly fashion and not having to have an urgent hearing, for example, on a Friday afternoon. And it is not right that my clients are in a worse off position because they've done that, rather than having fought tooth and nail to resist even a temporary injunction pending a decision on the injunction application. So, and that is a factor which should weigh with your lordship. So, in those circumstances, the fair way of doing what will have the least risk of injustice is by allowing my clients to sell those 175,000 packs.
All right. Well, in my view, given where we are, the right way forward is to preserve the status quo. But I accept Mr. Abraham's point that that should be done in a way which is least prejudicial as possible to Glenmark's position as it appears at the moment on the materials before the court as the first mover in this market. And in those circumstances, I think the fallback position of allowing the product that's presently in the lorries to go to the wholesalers, but on terms that it's not to be released for further sale or distribution, is the right way forward. So are you able to give an undertaking in those terms, or do I need to grant an injunction?
I obviously can't. I just need to explain to my clients exactly what your lordship has decided and the ramifications. May I?
Yes, of course.
Grateful, my lord. I just had to explain what the point was. So yes, we'll give that undertaking with the qualification that it will be on terms that it's not to be released to pharmacies.
Right. Very good. Anything else?
Sorry, not to be. Yeah, as you said, not to be released for further sale or distribution.
Yes.
Which is your wording.
Yes.
3122, my lord, which is a matter agreed between the parties, but obviously there is confidential information my lord will have read.
Very good. I will make an order in that form. I presume Mr. Tappin made an order and it can replicate the order that he made.
He did, my lord, yes.
Very good. Well, thank you all for your assistance. Let me return Mr. Pritchard's terror before I forget. And that's the end of this hearing. I meant to say, I knew I wanted to say something more. Could you agree and lodge an order for the court's approval?